That crime was committed, as Your Honor knows, as a direct result of the flight from the murder in this case. And that individual, the victim in that particular case, was home alone. Both Mr. Whitaker and his co-defendant, Mr. Barner, broke into that home and held her there against her will for over an hour. And she was also physically grabbed and thrown to the ground. And it was a terrifying event for her, so I would ask for a consecutive sentence in count 2.
All right, thank you. All right, then Mr. Whitaker, if you'll come forward, sir, for sentencing.
Ms. Schlax, I believe, is already in agreement with this, but just for the court, there are 2 restitution orders in Mr. Whitaker's case. One is for $1,200, and that is for Ms. Buckley, damage to her glasses and loss of her cell phone. And there is a $7,500 restitution order that is to victims' crime compensation, and that is for funeral expenses that were paid out. And I will have some restitution orders in Mr. Robinson's case.
Okay. And so, to be clear, Ms. Schlax, no objection to these 2 restitution orders?
No legal objection, Your Honor. As to the second amount of the $7,500 of the funeral expenses, I assume it will be jointly and severally liable with not only Mr. Hakeem Robinson, but Mr. Dominique Barner, who has entered a plea in this case, admitting his involvement, as well as Abdul Robinson Sr.
And the restitution orders do reflect any money paid by any other responsible co-defendant. We'll go towards that as well.
Okay. I'm not sure if Senior is considered a co-defendant necessarily in this case for him to share in that expense. Perhaps he is. I don't know. I'm not making that determination today.
Certainly.
Also, just to be clear, these have to be submitted electronically. I'm not signing these. That's the new policy from your office and ours.
I will have them submitted electronically.
You'll need to submit those electronically for my signature. Okay. You wish to say anything? Okay. All right, then, Mr. Whitaker, of course, you sat through the trial, as did I, and on July 31, this jury did find you guilty both of count 1, murder in the first degree, and count 2, burglary with an assault and battery. A unanimous vote by the jury. And so today I will adjudicate you guilty of each of those 2 counts. And on count 1, the murder in the first degree, this court has no choice but to sentence you as required under the law to a mandatory term of life in prison without parole. You will get credit for 1,995 days already served. As to count 2, the burglary with assault or battery, that is a first-degree felony punishable up to life. And this court does find that what Ms. Buckley experienced and sustained merits a sentence of life in prison as to count 2. That will run concurrently with count 1 and with credit for 1,995 days already served. I will impose the mandatory felony court cost of $518, a $150 total appointed attorney's fee. A restitution order will be entered against you jointly and severally with your co-defendants as to $7,500 to the Victims' Crimes Compensation Trust Fund, $1,200 payable to Ms. Buckley, and that will conclude the sentence. You do maintain the right to appeal both judgments and sentences that I have imposed today, and if you cannot afford an attorney for that appeal, one can be appointed to you, but a notice of appeal must be filed within 30 days. Do you understand that?
Yes.
Okay. Is it?
And Your Honor, we are prepared to file that today.
The notice of appeal?
Yes.
Okay. Do you need me to appoint counsel then?
I would ask at this time. His family may elect other arrangements in the future, but I would ask for that at this time.
Okay. Then I'll appoint, at this juncture, I have to start with the Office of the Public Defender for purposes of appeal.
As I was in the courtroom today when Robinson and Whitaker found out they'll be spending the rest of their lives behind bars without parole. Now, both men declined to speak as the judge announced their sentences.
His life was taken unjustly, and the ripple effect of the act that has forever changed his family, friends, and community. But it brings some kind of relief knowing that this individual will no longer have the power to take another life.
Is there anything you wish to say? Okay. By unanimous verdict, and at this time this court will then adjudicate you guilty of that offense and sentence you to the only lawful sentence that this court can impose, and that is mandatory life in prison without the eligibility for parole.
Jacksonville rapper Hakeem Robinson, also known as Ksoo, and his cousin Leroy Whitaker Jr. were sentenced Wednesday to life in prison without parole. for the 2020 killing of 23-year-old Charles McCormick Jr. According to the police, McCormick was shot on January 15, 2020 at Dames Point Plaza in Arlington. An off-duty officer witnessed the shooting and said the gunman stood over McCormick and fired a rifle before fleeing in a Nissan Altima. The officer pursued the car until it crashed. 3 people ran from the scene. Robinson and Whitaker were later arrested and charged with first-degree murder. A jury unanimously found Robinson guilty for first-degree murder on July 31st of this year. Family members of McCormick were in the courtroom, sharing their grief and sending a message to the community.
We pray that this moment causes reflection, not only for those being sentenced, but for anyone listening. One reckless moment, one decision can destroy many lives, including your own. As a community, we must take a stand against music and messages that glorify real violence and the loss of innocent lives.